doing now? What you doing now? If you can hear me, make sure you give me a thumbs up. Make sure you hit that like button. Please. Hit that like button. Hit that like button. Hit that like button. What's good with it? What's good with it? Yes, y'all getting the hang of it. So I'm going to get that chat call out the way. Queen Christy, you were first. Woo! Hey, Shorty. Karen J. Hey, Queen Diva. Hey, Pretty Piece. Liar, liar. Chi-Town OG. Lavelle Marshall. What's good with it, son? What's good with it? And everybody that's looking in the bushes. I'm sorry, in my window. I'm sorry, I don't have bushes. I have windows. I hope y'all had a good day. Listen, I'm so happy. When I tell you I am a happy camper, child. Boy, I'm trying to tell you, I am enjoying coming on YouTube because usually, I like to come on YouTube. When we have something to talk about, like some paperwork or whatever, and I still got all those indictments from Young Thug and all them goddamn other people, whatever, that we're gonna sift through at some point. But finally, we got something in from the prosecution, and it is a good read, y'all. It is a good read, so make sure those people stay up on that like button. For the people that's been asking for some more Lifetime movies, I got those keyed up and ready to go. I like to drop them on the weekend because it's to give y'all some weekend variety or whatever. Today, my chef friend who won that thing on Food Network, was it Food Network or Bravo? One of them. He did a video. I was trying to share it. I know I can share it. He did it on Instagram. I know I can share it on Instagram, but I'm going to see if I can get it to post it up here. He gave me permission to share it. He's a chef, and you can follow him if you're into cooking and all that type of stuff. He has his own lines of seasonings and things of that nature. What I was going to tell y'all. Oh, let me go and get this out the way. I swear, I had done hit the ignore button on a lot of this stuff because I'm too old for this. That's one. And I have better things to do with my time. And, child, it's not even worth my time. But when someone else is involved, I have to say something because, honey, I don't hit the ignore button. Listen, I ain't got no time for the miserable Bettys. I don't have no time for that. But let me show something, right? So apparently there's some issue with some goddamn transcripts that was allegedly stolen and given to me, or what have you, stolen from Diva and given to me, as if I cannot purchase transcripts. I have purchased or helped purchase a whole bunch of transcripts if people tell the truth. If people won't tell the truth, there's a lot of people that got transcripts off of me, didn't pay a dime, and we swapped them like that. If people want to tell the truth, I'm not talking about Diva. But if people want to tell the truth, but that, of course, that's not how we do around here. But I always have it in case a motherfucker call me a liar. All right. Even JoJo don't play for transcripts. Okay, so kill that bullshit. But this is the crazy shit. It was said that they identified a transcript because it had some IP address attached to it. See, baby, when you're lying and you're high, you just make up all kind of ridiculous shit. That makes no motherfucking sense. And if I told y'all what was my last post before I left the the work field, the workforce, like going into an office, you'll be like, really? So I know, you would know if I told you, you would know I know not all things when it comes to internet security, but enough. And JoJo says, I wouldn't tell, I wouldn't disclose that information. You talk too much, you tell everything. Yeah, because I ain't got shit to hide, right? So, but let me, once again, and this is so fun, because, and I wouldn't even be addressing this, because I done hit the ignore and motherfucker please button. You got to be out your motherfucking mind. Um, if you think that's how it really, what you saying is the truth, or how it really goes. And I ain't scared of a motherfucker. All right. And I think everybody knows that. But anyway, child, I'm at another place in my goddamn life, honey. Happy as hell, baby. But listen, people conveniently left out what I said yesterday when I got the transcripts. I didn't even know it was a transcript was generated until I heard Sylvia read it. Okay. But two people sent me the transcript. I said two. And I thanked two people. I ain't called their name. I thanked two people. When I went to go read it yesterday, I went to my email and I popped up the last person who sent me the transcript, which is not the person that they are accusing. But to let you know something, I pulled up both transcripts, both copies that were sent, and they are the exact same. There's no barcode, no IP address, none of that foolishness on there. I already know that. But I'm just saying, people have to sweeten the lie for whatever reason. I don't understand it. I really don't understand it. It's just like, whew, child, if you focus on other stuff and other than bullshit, maybe your life will go in a different direction. But when you don't have nothing more to do but sit around and you can't do nothing else, you need assistance or help or whatever to do whatever it is, you come up with all this kind of crazy shit. But I'm going to show you. I'm going to show you my email. I love this type of shit. Like, who the fuck would fuck with somebody that comes from an evidence background? Well, what the fuck? I just don't know. But anyway, I'm going to show y'all my email. And I hope this person don't mind me showing who sent me the paperwork, the last one that I clicked on. But I'm going to show you. If you look, that's my email. See that person right there? If you can see it, hold on. This person right here, this is the June 1st transcript. Okay? That's what I clicked on and read. So the notion that some kind of identifying marks, which was none on there, said that it was the stolen transcript from somewhere is ridiculous. The only reason why I'm saying addressing something because somebody else was thrown into this, and those people have never sent me anything being messy, talking about nobody, and none of that. Have never engaged in no whisper, or nobody has ever engaged into some messy shit with me. You know what I'm saying? And talking about somebody, whatever. Yeah, somebody sent me something, you know, before, but it wasn't those people. Somebody totally different. Unbelievable. But they do all this shit like somebody scared of their motherfucking ass. Are you serious? Oh Lord! But anyway, that's the reason why I'm addressing that because I'm not addressing misery. I can't do it. Nope. That I'm not about that. I'm not about the back and forth. I'm about the shutting up and putting in motherfucking work. How it's gonna go down, that's how it's gonna go down. And it don't have to be no back and forth about it. It's ridiculous. I don't even watch certain people. For what? For what? Anyway. Whoo, child. Let me tell you something. When you venture out and you don't hang with the type of people that you're accustomed to hanging with, this is what you get. So stick to your own kind. I am from now on, because that is petty as hell. And I don't like nobody being accused of shit. You know what I'm saying? They too nice to tell you to kiss my ass, fuck you, and run into a motherfucking building and 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 stay there until an ambulance come and ply your ass up off it. I will tell you that and mean it. Get your ass on. Never seen no shit like this. I don't have a problem with attachment and abandonment and shit like that. I'm an only child. I got a whole bunch of friends, real ones, best ones. I done got them on the motherfucking line. Like, so what? I don't know you. But yeah, so, child, oh my gosh, let that shit go. Woo. But anyway, moving right along. You see how many? I see how long I give shit like that. And shout outs to Levi, right? Levi is a person, a diplomatic type of person, who apparently knows how to get a beef settled, right? He don't pick no sides. He's not talking about one person or the other, whatever. He makes some intellectual points why beefing with one another is ridiculous. And being that you heard him say it, Dana is his nephew, and he like me. He gave me the position as his legal analyst. I almost said assistant. You know he like that word assistant on his channel. Yes, I'm wearing that title. Sky's on him. I mean, Sky Life and myself. We are his resident legal analyst. Okay, on Levi for Kelly. But being that he make good points and make common sense why Dan and I shouldn't be beefing and stuff like that, right? Now I don't know how long that's gonna last, because Dana be starting shit. and I be trying to finish his ass. But so yeah, shouts out to Levi. I ain't that type of person to want to keep going back and forth, whatever. I want to get to the part where we fight, get to the part where we destroy each other, but we ain't got to do that verbally spawn back and forth, because that's not doing nothing. All right. All right, take care of your ass and be done with it. Or you take care of my ass and be done with it. I ain't got to go back and forth, because that's stupid. Shit. Or let it go. But shouts out to Levi for that. So anyway, so hey, I listen. So the government sent in their sentencing memorandum. It's all under the umbrella, I told you, of sentencing materials, right? We are still waiting for I think the mitigation the expert report will probably come along with the sentencing submission, right? So all of these things are part of Mr. Kelly's sentencing materials. The government has their part, and J-Bo has her part. We finally has the government part. I skimmed through it, and I found some interesting stuff. Y'all are going to be surprised. Now, I predicted that his sentence would be at least 25 years. That is what the government recommend, 25 years and above. Okay? And I'll lay out the reasons why. So this is it's pretty extensive. So y'all gonna have to bear with me, but make sure they are liking us up. Cause you know the chat be lit, the panel damn show be lit, hell be on fire. So, but we're gonna go through this. Now you know I had said I like to go last, you know, because a lot of people, since we all doing our own thing, no one is helping each other or anything like that. We got to do our own reads, our own breakdown, our own analysis or whatever. You know, I like to go last. Because motherfuckers like to quote what you say, but don't want to give you credit. And I did warn, if you repeat anything I motherfucking say, call you out. Get your own breakdown, your own understanding. Shit. And I can be nasty too. I could be nasty too. But listen, y'all are going to, I don't know how y'all gonna feel about some of this. I also have but it's in the background, J-Bo's sentencing memorandum, part 1. Remember when she sent hers in? Because I wanted to compare her area, right? Remember the area where she did her groupings pursuant to what is USSG, and I forget the numbers. You can do the groupings like that. You're going to see, and I told you it was going to be different when the government submit theirs in. Those areas, I mean, most of the areas are different, but those, the groupings and stuff, they were going to be different. And it was. So, but anyway, so let me get to reading. This is a lengthy document. Let me see. It is 31 pages. And now I have to read my own shit. Ooh. Okay. So this is from the government. It says, Dear Judge Donnelly, the government respectfully submits this letter in connection with the sentencing of the defendant, Robert Sylvester Kelly, scheduled for June 29, 2022. In light of the seriousness of the offenses, the need for specific deterrence, and the need to protect the public from further crimes of the defendant, as well as the other factors set forth in 18 U.S.C. Section 3553A, the government respectfully submits that a sentence in excess of 25 years is warranted. The background. The evidence adduced at trial consisted of testimony from 50 witnesses. And you know, adduced means submitted or elicit. testimony from 50 witnesses, 45 witnesses called by the government, and 5 called by the defendant, and hundreds of exhibits admitted at trial. A complete summary of the evidence, including the enterprise, its purposes and methods, supporting each of the counts of which the defendant was convicted, was included in the government's opposition to the defendant's motion for a judgment of acquittal. Government's memorandum of law in opposition to the defense motion for judgment of acquittal dated March 21st, 2022. Reference, which detailed factual summary in is incorporated herein by reference. As established at trial and set forth in the pre-sentence investigation report, PSR, and its addendum, with the aid of his inner circle and over a period of decades, the defendant preyed upon children and young women for his own sexual gratification. In order to carry out his many crimes, the defendant relied upon his fame, money, and popularity as an R&B recording star and used the large network of people his status afforded him, including his business managers, security guards, and bouncers, runners, lawyers, accountants, and assistants, to both carry out and conceal his crime. Wait a minute. Hold on. I ain't read that part. Where's Levi Paquette? Where's Levi? You hear what they said? They said the defendant relied upon his fame, money, and popularity and an R&B recording star and used the large network of people his status afforded him, including his business managers, security guards, and bouncers, runners, lawyers, accountants, and assistants, to both carry out and conceal his crimes. He continued his crimes and avoided punishment for them for almost 30 years and must now be held to account. Generally speaking, the conduct underlying the defendant's crimes of conviction falls within the following 4 categories. 1, enticement of children. 2, the sexual exploitation of children through the production of child pornography. 3, forced labor. And 4, exposure of genital herpes without first informing his sexual partners and obtaining consent to sexual intercourse in these circumstances. Number 1, enticement of children. As established at trial, the defendant has a long and pervasive history of enticing children to engage in sexual activity, including when they were too young to legally consent to sexual activity. His career as a recording artist and performer took him all over the United States and the world for concert tours, other performances, and events starting in the early 1990s, and he quickly took advantage of his access to adoring fans and musical hopefuls who jumped at the chance to meet him. He lured young girls and boys into his orbit, often through empty or conditioned promises of assistance in developing a career in the entertainment industry, or simply by playing into the minor's understandable desire to meet and spend time with the popular celebrity, notably believing, rightfully for a period of time, that his fame and role as leader of the enterprise made him untouchable. The defendant often engaged in this criminal conduct in plain sight, doing so around and or with the assistance of others. In the early 1990s, the defendant sexually abused Jane Doe number 7, who testified at trial using the pseudonym Angela, beginning when she was 14 or 15 years old. The sexual abuse began immediately after the defendant met Angela for the first time at his small 2-bedroom apartment, along with at least 2 other girls who were also in high school and with whom the defendant also engaged in illegal sexual activity. The defendant sexually abused Angela and the other girls in his bedroom while members of his inner circle were in the living area directly outside. As would become a pattern, the defendant made clear to Angela and the other girls who the defendant later formed into a girl group, and in the case of Angela, employed as a background dancer for his tours. That sexual activity with him was the price of admission to be around him and get access to any opportunities he could provide them within the music industry. As Angela testified, the defendant made clear to her and other girls in no uncertain terms that they had to pay their dues and engage in sexual activity with the defendant at his direction at times for violating his rules. And that's a reference. Let me see. Okay, so in 1992 or 1993, the defendant met Aaliyah Houghton, an aspiring singer who subsequently became his musical protege and began to sexually abuse her when she was just 12 or 13 years old. The defendant used his access to young Aaliyah, claiming to need extra time alone with her for rehearsal and bringing her on tours to show her the ropes, to carry out his abuse of her, one time even shamelessly sexually abusing her by giving her oral sex in the back of his tour bus while others were in the vicinity. Faced with the possibility that his abuse of Aaliyah would be made public after she believed that she was pregnant at just 15 years old in August 1994, the defendant gathered members of his enterprise to help him carry out the bribery of a government official so that he could fraudulently and surreptitiously, marry Aaliyah in an attempt to conceal the abuse and avoid punishment. Not only did the defendant abuse Aaliyah, who became of her untimely death in a 2001 airplane crash, could not testify at trial, but he made her party. Let me get my glasses. I can't see shit. Hold on. Okay. But he made her party to the criminal cover-up scheme, having her fraudulently sign a marriage application using the illegally obtained identification to falsely claim she was 18 years old. In September 1994, just days after secretly marrying 15-year-old Aaliyah, the defendant sexually assaulted a 17-year-old girl identified in the PSR as Jane Doe number 8 and who testified at trial as Addie, after two of the defendant's associates approached her and brought her and a friend backstage to get the defendant's autograph after a performance. Because Addie was just 17, she was not old enough to consent to such sexual conduct in Florida. Addie was brought to the defendant's dressing room, which was filled with press and other men, where she spoke briefly to the defendant, who not only provided his autograph on her concert program, but also wrote down his hotel room number, about the fact that she was an aspiring dancer. True to form, the defendant mentioned the possibility of an audition, and after learning from Addie that she was 17, he had his associate clear the room of everyone except for him, Addie, and her friend. Within minutes, in that locked dressing room, the defendant began kissing Addie and her friend, became aggressive, moved Addie to one side of the room, held her wrist, pulled down her shorts, and penetrated her vagina from behind with his penis. When the defendant was finished, shocked and scared, Addie ran from the room with her friend. Let me see if I can see it clear here. In about 1998, the defendant noticed Stephanie at the Rock and Roll McDonald's in Chicago and had one of his associates approach her, point the defendant out, and give Stephanie the defendant's telephone number, notwithstanding that Stephanie had informed the associate she was only 16 years old at the time. Stephanie discarded the phone number and did not contact the defendant at the time. Approximately a year later, when Stephanie was 17 years old, she approached the defendant after learning that he was a nearby Nike store to see if he was willing to listen to her friend, an aspiring vocalist, sing and potentially help that friend with her career. The defendant told Stephanie that he thought we could arrange that, but he'd like to get to know Stephanie, and he also said that he likes to cuddle, and would Stephanie be okay with that? To which Stephanie responded yes. Reference. The defendant then gave Stephanie his telephone number and told Stephanie to call him, which she ultimately did. Thereafter, the defendant invited Stephanie to his Chicago studio, and the two ultimately engaged in sexual intercourse. Notably, the defendant was aware of Stephanie's age, as Stephanie told him she was 17. On either the first or second occasion she visited defendant's studio. They continued to have sex over the next approximately 6 months. Stephanie's sexual interactions with the defendant were humiliating. Reference. Stephanie described those interactions as follows. He would be very specific in how he wanted me to be. He would put me in positions that he wanted me to be in. He would tell me that he wanted me. He'd tell me to get undressed, and then he would position my body in a way, and he would then say, "All right, I'm going to go, and when I come back, I want you to be just like this." So I would just be completely naked with my butt in the air and just like waiting there for him to come and have his way, sometimes hours. Reference. When the defendant returned to the room and Stephanie was not in the position he had told her to be in, the defendant became very disappointed and angry, yelling at her. At some point after Stephanie had told the defendant she was 17, and while she remained 17, the defendant took Stephanie to his townhouse and directed her to participate in his creation of child pornography, videotaping her naked and as he engaged in sexual activity with her. On another occasion, in approximately October 1999, Stephanie traveled to see the defendant in Orlando, Florida. While there, the defendant took Stephanie to a recording studio and used a handheld video camera to record Stephanie's face as his penis was in her mouth and she was giving him oral sex. In yet another act of humiliation, the defendant ejaculated on Stephanie's face and did not let her wipe it off, instead telling Stephanie she had to walk down the hall in a more public area of the studio to another bathroom to wipe her face. During the course of her time with the defendant, he made clear to Stephanie that she was not permitted to speak to other men. On one occasion, she was at a Houston's restaurant in Chicago with the defendant and two rappers. Stephanie was not allowed to speak to the rappers during the meal, but heard the defendant tell them that he likes young girls and that people make such a big deal of it, but it really isn't a big deal because even look at Jerry Lee Lewis. He's a genius, and I'm a genius, and we should be allowed to do whatever we want because of what we give to this world. Reference. Thus evincing his clear belief that he could act with impunity in committing crimes involving minors because of his self-proclaimed musical genius status, which in his mind constituted a free pass to do as he pleased without consequence. In 2005, the defendant spotted Alexis, then just 15 years old, after one of his concerts and thereafter began a year-long sexual relationship with her. That same year, the defendant met a teenage boy who testified at trial using the pseudonym Lewis, then 17 years old, while he was working at a McDonald's close to where the defendant played basketball at the time. After first meeting, Lewis, the defendant, again used his status in the music industry to induce Lewis to meet with him again. The defendant also groomed Lewis and his family, inviting them to a party at his home and having Lewis meet him at his home studio in Olympia Fields. When the defendant had Lewis alone, he asked Lewis who had dreams of making it as a rapper, what Lewis was willing to do to make it in the business, after which the defendant gave Lewis, still just 17 years old, oral sex and video recorded their sexual encounter. On another occasion, the defendant also directed a female who Lewis did not know to give Lewis oral sex while the defendant watched. Lewis testified that the defendant made clear to Lewis that sexual contact with him was a prerequisite if Lewis wanted the defendant to help him in the music business. Like others, the defendant's promises to help Lewis in the music industry were empty and instead just deployed to entice a 17-year-old boy to have sexual contact with the defendant and others at his direction, and on certain occasions to film that conduct. In 2009, and continuing for a 6-month period into 2010, the defendant sexually abused Geronda, who was then 16 years old and a big fan of the defendant's music. The defendant invited Geronda to his home and, once alone with her, directed Geronda to remove her clothing and walk back and forth naked before him. The defendant thereafter engaged in sexual contact with Geronda and then had sexual intercourse with her, at times described further below, making sexually explicit videos of Geronda while she was 16. That same year, the defendant began to have sexual contact with Dominique, who was just 17 years old. To meet Dominique, the defendant relied upon the 16-year-old Geronda to introduce him to Dominique, one of her friends. In 2015, the defendant met another young girl who testified under the pseudonym Jane at trial, who was 17 years old, after spotting her at one of his concerts and using members of his entourage to ensure Jane received his telephone number. Shortly thereafter, the defendant engaged in sexual contact with Jane under the guise of an audition in his hotel room and soon convinced Jane to travel across the country with him and ultimately to spend her senior year of high school living with him. In April 2015, the defendant arranged for Jane to travel from Orlando to Los Angeles to see him. Again, the defendant promised to help Jane with her musical aspirations, a false promise that he used to entice her to remain with him. Notably, when Jane disclosed to the defendant that she was 17 years old, rather than end his relationship with Jane, the defendant arranged for the mother of another of his girlfriend's Juice to serve on paper as Jane's purported legal guardian while the defendant continued to travel, live, and have sex with Jane. During the course of time, Jane was with the defendant, and as described in more detail below, he prescribed a number of rules for Jane and his other girlfriends to follow, exercising coercive control over them. The defendant began enforcing these rules shortly after Jane met him by punishing her when she did not follow his prescribed rules or comply with the established protocols. Those punishments include spankings, which the defendant called chastisements, vicious physical assaults, and confinement of Jane to a room or a bus for prolonged periods of time. 2. The production of child pornography. For decades, the defendant also created and maintained child pornography. Several witnesses testified that the defendant recorded their engaging in sexual activity with the defendant and others at the defendant's direction. Witness after witness described how the defendant scripted every aspect of the sexual activity, acting as the writer, producer, and director of each encounter. As described above, in 1999, the defendant sexually exploited Stephanie. He summoned her to his house where he filmed her engaging in sexually explicit behavior and then having sex. Fearful that the recording might be distributed, Stephanie begged the defendant to return or destroy the recording, but he never did. To this day, Stephanie fears that the recording still exists. In later years, the defendant also recorded Geronda and Jane, also engaging in sexually explicit conduct while they were each under 18 years old. Number 3, forced labor. The defendant methodically groomed the women and girls in his orbit to meet all of his sexual needs. First, he promulgated an extensive set of rules. He had the women and girls call him daddy and directed them to wear sweats or other baggy clothing. When he entered a room, he expected the women and girls to immediately stand and greet him with a kiss. In more recent years, including the entirety of the time James spent with him, the defendant's coercive tactics grew even more brazen. The defendant did not permit the women and girls to speak with or even look at other men. In an elevator, they were expected to turn to face the back. While walking through hallways, they were expected to look to the floor. In commercial establishments, they had to direct their inquiries to a female employee or leave the establishment. As part of his grooming process, the defendant severely isolated the women and girls. The defendant discouraged communication with their family members and friends and prohibited the use of social media. They were also not permitted to exchange personal information with the other women who lived with the defendant. When the defendant arranged for women and girls to visit him, the defendant required them to spend their time waiting for him in a location that he dictated. Within a few weeks of meeting the defendant and traveling to Las Vegas with him, Jane tried to go to the mall, but an assistant made clear to her that she would need to first get the defendant's permission. Jane told her mom everyone was having fun, but the defendant told her, "Do not leave that room." Government Exhibit 233I. Faith testified that she spent hours on a sprinter van waiting for the defendant, only leaving to go to the bathroom and only when she had the defendant's permission. Reference. More generally, witnesses advise that they often accompany the defendant to meetings, social gatherings, and restaurants and bars and other events, but the defendant often directed them to stay on the sprinter van while he went to the meeting, gathering, or event. If they needed a bathroom and could not obtain permission from the defendant to leave the van, they had to urinate in a cup. When the defendant learned that one woman had left the bus at a pit stop during a long distance drive without first obtaining the defendant's permission, he became enraged. An assistant testified that when the defendant learned of this transgression, she had never seen the defendant so upset. Reference. 1 minute, let me take a drink. The defendant required the women and girls to regularly write letters purportedly confessing to generally false criminal activity and other embarrassing conduct. In these letters, they falsely confessed to stealing money and jewelry and falsely admitted, concocting elaborate robberies. One falsely claimed that that she seduced the defendant when she was underage and threatened to claim he raped her if he would not engage in sexual activity with her. For safekeeping, the defendant kept certain of these letters in a document protector and in a locked safe. So, guys, so that's where, remember, a lot of people was asking, how did they, why was the letters in court in some type of protection vehicle or whatever? So that answers that question. It says that the defendant kept certain of these letters in a document protector and a locked safe. Okay. The defendant also had certain women record videos in which they falsely claimed that family members had abused them. To make the allegations in these recordings appear genuine, the defendant directed the women to make their confession shortly after he had physically assaulted them, and he caused them to shed real tears of pain. The defendant also directed certain women to make videos depicting themselves engaging in humiliating behavior. At least three women made videos of themselves eating feces and rubbing it over their bodies. He filmed another young woman walking back and forth naked, making derogatory comments about herself, which he directed her to repeat over and over and over after first spanking her multiple times. The defendant required the women and girls to abide by all of his rules and punish anyone who violated those rules. He once sent a message to Jane: I knew you were young, but that is no excuse to disobey me or not to do what I tell you to do. Government Exhibit 481. Significantly, the defendant also required women and girls to report any perceived violations by others. The consequences for disobeying the defendant included violent spankings, other physical assaults, physical restraint, and threats. He imposed these spankings on a regular basis. Jane recalled their occurring multiple times a week for a period of years. The spankings were painful, as she made clear by one such incident video recorded by the defendant and played for the court and the jury. Government Exhibit 382A, Government Exhibit 328B, For what he perceived as greater violations, the defendant physically assaulted the women and girls using shoes, extension cords, and other objects in his grasp. On other occasions, he required the women or girls to remain in her room or on a bus for prolonged periods of time. On one occasion, he told one young woman who he perceived had disobeyed him that people are murdered for doing shit like this. Government Exhibit 485B. He then told the same woman that she needed to be on his team or else. Government Exhibit 485B. If you bullshit me now, then I'm going to look at you like you're not on my team at all. The physical abuse by the defendant was severe. For example, Jane testified that on one occasion, the defendant spanked Jane and two other women who then lived with the defendant 15 times after they paired off and spoke openly about their relationship with defendant in violation of the defendant's rule. Reference. On another occasion, when Jane was just 17 years old, stood 4'11" and weighed a mere 98 pounds, the defendant beat Jane all over her body with his fist and his shoe. Reference. Jane also testified that she saw the defendant physically abuse his living girlfriends. Reference. I have seen him slap his other living girlfriends open palm. I have seen him drag them by their hair. I have seen him punch them in their face and all over their bodies, and I have also seen him hit them with objects. I have seen the defendant also use shoes, and also once I did see him use a cord of some sort. Sometimes, as punishment, the defendant confined women and girls to a particular location for a prolonged period of time. Jane testified that the defendant sometimes directed her to stay in a room until he determined that she had sufficiently apologized. Reference. Text messages from December 2015 to one of her close friends directly supported Jane's account. She wrote, I was like, can I take a shower? Can I take a shower? And he, the defendant, was like, no, you're going to stay in the room. Government Exhibit 935B. One of his assistants saw the defendant's abuse and contemporaneously commented that Jane had been confined since the day before. Government Exhibit 240C. On another occasion, an assistant saw that the defendant confined Jane again. this time for a 2-day period, and relied on the assistant and another woman to ultimately keep watch over Jane. Government Exhibit 240F. Relying on the pattern of activity described above and much more, the defendant regularly required the women and girls to engage in sexual contact with him and others upon his command, including upon threat of physical violence. For example, the defendant's sexual and physical abuse of Geronda culminated when the defendant slapped her and choked her until she passed out, spit on her, and told her to put down her head in shame. Reference. When Geronda got up off the floor, the defendant instructed her to perform oral sex on him. Reference. And after Geronda complied with his instruction, he ejaculated on her face. After regularly physically and psychologically abusing Jane and other women, he required them to have sex with other women and even men. The defendant directed when these encounters took place, who participated, and the particular sexual acts performed during the encounters, and often recorded them. The defendant regularly required Jane to have sexual contact with the other men and women at his direction, including the women living with him, his assistants Lily and Cassandra, and a man he referred to as nephew, whom she had never even seen prior to the defendants directing her to have sex with him. One such sexual encounter was vividly depicted in Government's Exhibits 341, 342, 343, a video of sexual encounter between the man Jane knew only as nephew, who testified as Alex, and another of the defendant's live-in girlfriends. The video showed the defendants directing the woman to give Alex oral sex and then to have sexual intercourse with him. Specifically, the defendant physically positioned the woman so that she was in the precise sexual position the defendant wanted, Government Exhibit 342C, and held onto the woman's hair, and as he forcefully and repeatedly pushed her mouth onto Alex's penis, Government Exhibit 342B. The defendant maintained total control throughout the encounter. In fact, his facial expressions showed two people who appear positively numb to what was happening. They just listened to the defendant and executed his commands. On another occasion, upset that Faith had broken one of his rules, the defendant required her to give him oral sex after bringing her into a tiny room where a gun was present, grilling her with questions and telling her that there would be consequences if she lied. With this gun nearby, the defendant then placed a pillow on the floor and told Faith to get on her knees, pulled out his penis, grabbed the back of Faith's neck, and told her to suck his dick, and pushed her forward to her mouth, made contact with his penis. Reference. Scared and intimidated, Faith acquiesced. As Faith described, she was under the defendant's rules and he had a weapon, so she wasn't even going to step out of line. Reference. In sum, the defendant used coercive control, exemplified by a pattern of isolation rules, dependent threats, intimidation tactics, physical abuse, and on at least one occasion, the presence of a firearm to force victims, including minors, to engage in sexual activity with the defendant and others at his direction and to become unwilling participants in his pornographic films he created. Number 4, exposure to genital herpes. Wait a minute, y'all. The defendant also exposed multiple men, women, boys, and girls to a sexually transmitted and incurable disease, genital herpes, without their knowledge or consent, notwithstanding that he had been explicitly told by his personal doctor to inform his sexual partners of his diagnosis and to use a condom when having sex. As early as 2004, the defendant had been diagnosed with the genital herpes and exposed a woman who testified at trial as using pseudonym Kate and other women, Jane Doe number 12, to herpes without their consent. Both sued him and received financial settlements in exchange for their silence, but the defendant nonetheless remained entirely undeterred by these financial consequences. Over the next 15 years, the defendant engaged in unprotected sexual intercourse with multiple partners, exposing each of them to genital herpes. As proven at trial, the defendant each of never disclosed. Well, this is written in small type, so I'm sorry. Never disclosed his diagnosis to Jane or Faith, and never sought their consent to engage in unprotected sexual activity in these circumstances, as did many of the defendant's sexual partners before her, including Geronda, when she was just 17 years old. Jane contracted genital herpes from the defendant, a serious medical condition she will have to live with and disclose to future partners for the rest of her life. As Jane testified, she was devastated after receiving her diagnosis. Let me see if I can make this bigger. Hold on for a minute, y'all. I can't see shit. Yeah, here we go. Okay. Reference. She explained, I felt that this man had purposely given me something he knew he had, a situation that he could have controlled. Reference. By contrast, when Jane told the defendant about her diagnosis, he appeared agitated and callously told her she could have contracted it from someone else. Reference. When she subsequently had the herpes outbreak, the defendant disparaged her, telling her, I think your pussy is broken. Reference. Discussion. 1. The guidelines calculations. In his sentencing memorandum, the defendant lodges several objections to the guideline calculations set forth in the PSR and PSR addendum. Additionally, the government objects to certain aspects of the guideline calculations in the PSR and the PSR addendum. Each of those objections is addressed below. Now, y'all gonna be shocked about this. Now, this is the government, so I kind of skimmed through, some of this, and this caught my attention. So let me drink some of this. Make sure, hey, Club Blue, make sure they like us up. Because if I'm not too tired, I remember I got to go back and read these footnotes, but I'm gonna try to do a side by side comparison of those groupings of those counts, right? You remember I told you J Bo, she kind of pencil whipped it, but I saw what the prosecutors did, and it was totally different. So, and I told you it would be, but it's real different. Okay. A. Racketeering Act 1, bribery related to Jane Doe number 1, Aaliyah. As to Racketeering Act 1, the defendant objects to the inclusion of a 2-level enhancement under USSG Section 3B14. And that section is where they tell you like how you're supposed to add additional points and how you're supposed to group them together, right? That is what Jabo was doing in her sentencing memorandum. Okay, it says, for the use of a person less than 18 years of age to commit the offense of bribery. May 27, 2022, Sentencing Memorandum 4. While the government agrees with the probation department that the defendant used Aaliyah, then 15 years old, to perpetrate the marriage fraud, the government cannot say that he used her to perpetrate the bribery itself, and therefore submits that the court should not apply this enhancement. So right there, they disagree with the PSR report. That's favor R. Kelly. All right. Now, this is the government. So they do not favor the 2-level enhancement for this particular reason. And J-Bo objected to the same thing with regards to Aaliyah. All right. B, Racketeering Act 2, Sexual Exploitation of a Child, Jane Doe number 2, Stephanie. As to Racketeering Act 2, the defendant objects to the 2-level enhancement pursuant to USSG Section 2G2 1B2A, which applies if the offense involved A, the commission of a sexual act or sexual contact. In the defendant's view, the enhancement is duplicative of the sexual conduct in the base offensive level. May 27, 2022, Sentence Memorandum 4.5, which is what J-Bo submitted. That is that reference that they are noting here. He is wrong. Sexually explicit conduct does not require the commission of a sexual act or sexual contact. Sexually explicit conduct, as defined by 18 U.S.C. Section 2256(2), reference, includes, among other conduct, lascivious exhibition of the anus, genitals, or pubic area of any person. By contrast, a sexual act or sexual contact, defined by 18 U.S.C. Sections 2246(2) and 2246(3), see USSG Section 2G2.1, Application Note Number 2, does not include and goes well beyond such conduct, instead covering contact between certain body parts and intentional touching of body parts. Accordingly, the enhancement is not duplicative. Reference. Rejecting defendant's argument that where a defendant was convicted of a violation of 18 U.S.C. Section 2251, the 2-level enhancement under Section 2G2.1B2A amounted to impermissible double counting. Okay? So she is disagreeing here. They're disagreeing there. Remember, J-Bo said with this particular error, it was duplicative, because I think she cited that it was already in the base level. If I can remember, it was already in the base level. To add another 2 point makes it duplicative. That's usually what it means. Duplicative. All right. C, Racketeering Acts 3 and 4, Kidnapping, Mann Act violation, Jane Doe number 3, Sonia. The defendant objects to the inclusion in the guidelines in calculation of the conduct related to Sonia as alleged in Racketeering Acts 3 and 4. May 27, 2022, Sentencing Memorandum 5. The government submits that Sonia's testimony was credible and supported by other evidence, and therefore is properly included in the PSR, while the government submits that this conduct has been proven by a preponderance of the evidence and constitutes relevant conduct pursuant to United States versus Ruggiero reference, because the adjusted offense level associated with the offense conduct Even absent conduct related to Sonia carries a life sentence. The additional conduct related to Sonia has no bearing on the adjusted offense level, and the government respectfully submits that the court need not make a finding as to whether it should be included in the guidelines calculation. United States versus Crosby, 397 F.3D 103, Second Circuit, 2005. Hold on. Now that the duty to apply the applicable guideline range is not mandatory, situations may arise where either of two guideline ranges, whether or not adjacent, is applicable, but the sentencing judge have complied with Section 3553A, makes a decision to impose a non-guideline sentence, regardless of which of the two ranges applies. This leeway should be useful to sentencing judges in some cases to avoid the need to resolve all factual issues necessary to make precise determinations of some complicated matters, for example, determinations of monetary loss. Let me make this big. I cannot see. Hold on. D. Racketeering Act 5, Mann Act violations, Jane Doe number 4, Geronda. Grouping. Hold on, y'all. Now, pay attention. As an initial matter, the government disagrees with the probation department's grouping of Racketeering Acts 5, 6, and 7. Section 3D1.2 of the United States Sentencing Guidelines, USSG, provides that counts involve substantially the same harm shall be grouped into a single group, and then set forth 4 means through which conduct should be grouped, including when counts involve the same victim and the same act or transaction. Remember when I was going through to see if J-Bo did that, and I was like, well, why is it group? Well, why did she group that together? That's not how it's supposed to be grouped, right? Remember I was going through that saying that? This is what they're saying. So it says USSG section 3D1.2A. Application note 3 explains, under subsection A, counts are to be grouped together when they represent essentially a single injury or a part of a single criminal episode or transaction involving the same victim. When one count charges an attempt to commit an offense and the other charges the commission of that offense, or when one count charges an offense based on a general prohibition and the other charges violations of a specific prohibition encompasses in the general prohibition, the counts will be grouped together under subsection A. Examples: 1. The defendant is convicted of foregoing and uttering the same check. The counts are to be grouped together. 2. The defendant is convicted of kidnapping and assaulting the victim during the course of the kidnapping. The counts are to be grouped together. 3. The defendant is convicted of bid rigging and antitrust offense and the mail fraud of signing and mailing a false statement that the bid was competitive. The counts are to be grouped together. 4. The defendant is convicted of 2 counts of assault on a federal officer for shooting at the same officer twice while attempting to prevent apprehension as a part of a single criminal episode. The counts are to be grouped together. Number 5, The defendant is convicted of 3 counts of unlawfully bringing aliens into the United States, all counts arising out of a single incident. The 3 counts are to be grouped together. But 6, the defendant is convicted of 2 counts of assault on a federal officer for shooting at the officer on 2 separate days. The counts are not to be grouped together. I told y'all she pencil whipped that grouping. I told y'all, go look back at the video. I was like, this ain't right. Okay, USSG section 3D1.2, application number 3. The government submits that the conduct that formed the basis for each of the racketeering acts as to Agenda number 4, Geronda, did not involve the same act and transaction and did not substantially involve the same harm and therefore should not be grouped. Rather, the conduct is more akin to the final example in the application note 3, where a defendant is convicted of 2 counts of assault for shooting at the officer on 2 separate days, a scenario where grouping is not called for. Racketeering Act 5, 6, and 7 relate respectively to 1, the Mann Act violation related to Jane Doe number 4, R.A.5. Number 2, forced labor of Jane Doe number 4, RA6. And 3, number 3, the sexual exploitation of Jane Doe number 4, Racketeering Act 7. As Jane Doe number 4 testified at trial on several occasions over the course of 6 months, the defendant, using his cellular phone, induced Jane Doe number 4 to come to his residence and engage in sexual contact with him. Separately, on several occasions over a 6-month period, the defendant video recorded Jane Doe number 4 engaging in sexually explicit conduct. And finally, in January 2010, the defendant caused Jane Doe number 4 to engage in sex and oral sex with the defendant by means of force, threats of force, physical restraint, or threats of physical restraint, and a scheme, plan, or pattern intended to cause Jane Doe number 4 to believe that if she did not perform such services, she would suffer serious harm or physical restraint. Even though the conduct overlap in time, these 3 types of conduct constitute separate acts or transactions and involve very different harm. Case law. 2 episodes of sexual misconduct that society had legitimately criminalized doing with the same person on different days are not substantially the same harm for purposes of section 3D1.2 point. Number 2, undue influence enhancement, section 2G1.3b2. As to Racketeering Act 5, the defendant objects to the 2-level enhancement pursuant to USSG section 2G1.3b2. May 27, 2022, Sentencing Memorandum 5 through 6. Section 2G1.3b2b provides that the enhancement is warranted when a participant otherwise unduly influenced a minor to engage in prohibited sexual conduct. Application Note 3B3 explains. In determining whether subsection B2B applies, the court should closely consider the facts of the case to determine whether a participant's influence over the minor compromised the voluntariness of the minor's behavior. The voluntariness of the minor's behavior may be compromised without prohibited sexual conduct occurring. In a case in which participant is at least 10 years older than the minor, there shall be rebuttal presumption that subsection B2B applies. In such a case, some degree of undue influence can be presumed because of the substantial difference in age between the participant and the minor. USSG Section 2G 1.3, Application Note 3B. Here, the defendant was 26 years older than Jane number 4, Geronda, thereby giving rise to a rebuttal presumption of Section 2G1.3B2B's application. The defendant attempted to rebut this presumption by claiming that Geronda was sophisticated and looked great and took great pains to get close to the defendant. May 27, 2022, Sentencing Memorandum 5 through 6, is absurd. Geronda was a 16-year-old girl who was a devoted fan of the defendant's music, nothing about which amounts to sophistication. By contrast, the defendant, a famous and wealthy musician who was 26 years her senior, induced her to engage in sexual contact with him, including after he learned that she was just 16 years old. Moreover, the defendant promulgated various rules that Geronda was required to follow in an effort to control Geronda and directed her to have sexual contact with others, including another woman, further evidencing the undue influence that he wielded over her. In these circumstances, the defendant has not rebutted and cannot rebut the presumption. The enhancement is therefore warranted. Number 3. Interactive Computer Services Enhancement, Section 2G1.3B3. The defendant objects to the two-level enhancement pursuant to USSG Section 2G1.3B3 for the use of a computer or interactive computer service to induce the travel of a minor. There is ample evidence in the trial record that the defendant relied upon cellular telephones to communicate with Geronda, including for the purpose of arranging her travel to Olympia Fields to meet with and have sexual contact with him. Among other things, such evidence includes telephone records and cellular telephone used by Geronda, both entered into evidence and at trial as government exhibits 139 and 210, showing telephone contact between Geronda and the defendant. The defendant's argument that he did not use a cellular telephone to induce Geronda to travel to meet him was squarely rejected by the jury when it found Racketeering Act 5 proven. The court should therefore apply this enhancement. Number 4. Commission of a sexual act enhancement, Section 2G1.3B4. The defendant objects to the two-level enhancements pursuant to USSG Section 2G1.3B4. Section 2G1.3B4 applies where the offense involved A, the commission of a sexual act or sexual contact. The defendant argues that the enhancement is duplicative of the sexual conduct in the charged offense. He is wrong. A violation of 18 U.S.C. Section 2422, the statute that formed the basis for Racketeering Act 5, is based on coercion of a minor for the purpose of illegal sexual activity and does not require that the illegal sexual activity in fact occurred. Wait a minute. The statute formed the basis for Racketeering Act 5 is the base on coercion of a minor for the purpose of illegal sexual activity and does not require that the illegal sexual activity in fact occurred. Okay, so it must be that was the intent, but they didn't do it. Accordingly, the enhancement is not duplicative. Case law, rejecting defendant's argument that two-level enhancement under Section 2G1.3b for A amounted to impermissible double counting because one could violate 18 U.S.C. Section 2423 without committing a sex act. This enhancement is therefore applicable. So must be in that one. Must be in that one. That is Racketeering Act 5. So it must be didn't have sex. But maybe the intent was there, and because it was this a minor, hold on. That is what made it a crime. Yeah. Okay. E. Racketeering Act 6, forced labor, Jane Doe number 4, Geronda. As to Racketeering Act 6, the defendant objects to the 4-level enhancement pursuant to Section 2A3.1b1. As an initial matter, Section 2H4.1b4 applies when any other felony offense was committed during the commission of or in connection with the peonage of involuntary servitude offense. Application Note 2 provides that any other felony offense means any conduct that constitutes a felony offense under federal, state, or local law, other than an offense that is itself covered by this subpart. USSG Section 2H4.1, Application Note number 2. When Section 2H4.1b4 applies, the guidelines dictate that the offense level should be increased to the greater of I, the adjusted offense level according to 2H4.1a to B3 plus 2 levels, or 2, the offense level form the offense guideline applicable to the other offense plus 2 levels provided it is not greater than 43. USSG Section 2H4.1b4. Now this is interesting. Hold on. As noted above, the government submits that Racketeering Act 6 should not be grouped with Racketeering Act 5 or Racketeering Act 7, and that instead each act should be considered separately. As a result, the government also disagrees with the Probation Department's assessment that the other felony offense that was committed during the commission of or in connection with the forced labor offense was sexual exploitation of a child in violation of 18 U.S.C. Section 2251A, PSR 162, PSR Addendum 162. In the government's response, the defendant's objection to the PSR, the government argued that the conduct nonetheless amounted to a violation of 18 U.S.C. Section 2241, aggravated sexual abuse, or 2242, sexual abuse, and therefore an enhancement under Section 2H4.1b4 was warranted. However, upon further consideration, the government does not believe that the enhancement is warranted, okay, because the conduct did not take place in the territorial jurisdiction of the United States, a required element to establish a violation of 18 U.S.C. Section 2241, aggravated sexual abuse, or 2242, sexual abuse. All right. Accordingly, the government does not seek the application of an enhancement under Section 2H4.1b4 Although the government does not seek that enhancement, it submits that the adjusted offense level without the enhancement under Section 2H4.1b4 does not reflect the full nature of the conduct, i.e., criminal sexual abuse, and the court may apply an upward departure under USSG Section 5K2.08. So remember, I talked to you guys about that upward and downward departures, whatever. So they're right there essentially with regards to this issue, they're asking the judge to sentence outside of the guidelines, but upward, meaning give more time. And they reference a 5K letter. All right. F. Racketeering Act 7, sexual exploitation of a child, Jane Doe number 4, Geronda. As to Racketeering Act 7, the defendant objects to the application of a 2-level enhancement for the use of a computer or interactive computer service to induce the minor to engage in sexually explicit conduct pursuant to USSG Section 2G 2.1b6. Section 2G2.1b6 provides that the 2-level enhancement is warranted where, if for the purpose of producing sexually explicit material, the offense involved the use of a computer or an interactive computer service to 1. Persuade, induce, entice, coerce, or facilitate the travel of a minor to engage in sexually explicit conduct, or to otherwise solicit participation by a minor in such conduct, or 2. Solicit participation with a minor in sexually explicit conduct. USSG Section 2G2.1b6, the government submits that the enhancement as described above, the defendant stayed in touch with Geronda by cellular telephone and regularly used a cellular telephone to communicate with Geronda in order to induce her to travel to see him and to instruct her to meet him in a location where he intended for Geronda to engage in sexually explicit conduct and to record such conduct. Woo. Let me get me a drink. Give me a minute. Let me check on y'all real quick. Woo. Y'all still hanging on in there? I'm around the front. Y'all still hanging on in there? Woo, thank y'all for holding, honey. I'm gonna need some more likes than that, honey. Shit. I feel like I'm reading a goddamn math problem. I'm right in the front. So in this section, you see where the government is agreeing or disagreeing with both the PSR or JBO. And although a probation officer, and I showed you the tool you use, right? Remember I showed y'all that tool when I was plugging in everything. I was manually doing it in real time. I showed you the sentencing guideline tools. I plugged it in so we can get the month range and all of that. And then I went and looked at the sentencing guidelines and all of that. So people are human, right? And I told you that with the PSR report, one is full of hearsay. Two, it's the probation officer's recommendation. So you get a lot of human error. The prosecutors, with their memorandum, or with this sentencing material, or whatever you want to refer to it as, they are going through to make sure that it's done correctly. And you know why? Because they don't want no shit down the line. Okay. I don't know who was in here, but I told you that the J-Bow's groupings weren't correct. That was in my opinion. Because it wasn't done per the procedure. Because I looked at the procedure and it wasn't done correctly. So I don't know how this is going to work out. So we'll see. Let me go and read the rest of it. All right. We have G, Racketeering Act 8, Mann Act violation, Jane Doe number 5. Jane, number 1, application of section 2G1.1 versus section 2G1.3. The government respectfully disagrees with the Probation Department's determination that the applicable guideline for Racketeering Act 8 is section 2G1.3 and instead submits that the applicable guideline is section 2G1.1. Because at the time that the defendant committed the conduct alleged in Racketeering Act 8, Jane had told the defendant that she was 18 years old, and she had not yet told him that she was, in fact, 17 years old. The government submit that section 2G1.1 is the more applicable guideline. So I wonder, are they saying that they want to make it fair because this could be that defense mistake of age, that she, pretty much allegedly caused this situation to happen when she lied about her age, right? I'll say the initial encounter. I guess that's what they're referring to. So let's see. Somebody remember that. Remember Racketeering Act 8, because I want to see what they say on when we get down to the calculation. Let's see what they do with the points. Okay, number 2, fraud enhancement section 2G1.1B1. As to Racketeering Act 8, the defendant objects to the 4-level enhancement pursuant to USSG section 2G1.1B1 based on fraud. The government submits the enhancement applies because the defendant failed to disclose that he had contracted genital herpes and engaged in unprotected sexual intercourse with Jane Doe without first disclosing to her his herpes diagnosis and obtaining her consent to sexual intercourse in these circumstances. Although fraud is not defined in the guidelines, the defendant asserts that a fraud requires the victim to suffer harm, but then offers no support for such contention. Moreover, no such requirement is included in the Merriam-Webster definition of fraud, which includes the intentional perversion of truth in order to induce another to part with something of value or to surrender a legal right, and an act of deceiving or misrepresenting. Accordingly, the 4-level enhancement is warranted. A long time ago, people thought I was crazy when I said with regards to this illegal sex, you got to get someone's, even though it's dealing with this herpes, you got to get someone's consent to have sex. And and I would say, well, most people would say, well, no, I'm not want to have sex with you and you got herpes. But this is the law. Moreover, though not required, the defendant is incorrect that Jane suffered no harm as a result of her unknowing exposure to the defendant's genital herpes through sexual intercourse in California in April and May of 2015. As Jane testified, that trip was first time she and the defendant had sexual intercourse. Because she was unaware of his genital herpes diagnosis due to the defendant's failure to inform her of it, Jane continued to have unprotected sexual intercourse with the defendant and thereafter contracted herpes from him, with which she was eventually diagnosed a few months later on August 14, 2015. Indeed, based on the evidence presented at trial and the reasonable inferences to be drawn from it, there is no doubt that the defendant intended to deceive Jane and all the other women and girls he had unprotected sexual intercourse without first disclosing his diagnosis. Years prior, he had been explicitly informed by his personal doctor to inform his sexual partners of his diagnosis and to use a condom during sex. He had also faced civil suits for infecting prior sexual partners with genital herpes. His preference for continued sexual intercourse without use of a condom clearly was more important to him than risking that a desired sexual partner would either decide not to have sexual intercourse with him at all or insist on the use of a condom if informed of his diagnosis. His decision not to disclose this material fact was clearly intentional and not the result of any accident or mistake. That kind of lays it out and answers a whole bunch of questions. H. Racketeering Act 9, Mann Act violation, Jane Doe number 5. Jane. Grouping. As an initial matter, the government disagrees with the Probation Department's grouping of Racketeering Act 9 and 10. Those acts relate to 1. The Mann Act violation related to Jane Doe number 5, Racketeering Act 9, and 2. The sexual exploitation of Jane Doe number 5, Racketeering Act 10. The Mann Act violation centered on the defendants arranging for Jane Doe number 5 to travel from New York to California for the purpose of sexual contact, despite that Jane Doe number 5 was too young to consent to sex. The sexual exploitation conduct related to the defendant's recording of Jane Doe number 5 engaging in sexually explicit conduct over the course of a longer time period. Even though the conduct overlapped in time, the conduct underlying each of these racketeering acts constitutes separate acts as transactions and involve very different harm. Case law. 2 episodes of sexual misconduct that society has legitimately criminalized occurring with the same person on different days are not substantially the same harm for the purposes of Section 3D 1.2. And that's how they count the different days and different time spans. That's why you see the same charge, but different at different times. That's why it's different counts. Number 2, application of cross-reference in Section 2G1.3C1. As to Racketeering Act 9, the defendant objects to the base offense level of 32, pursuant to USSG Sections 2G1.3C1 and 2G2.1A, and submits that the proper base offense level is 24, pursuant to Section 2G1.3A4. Wait a minute. Objection based on 32. Okay, so they went down from 32 to 24 in this particular situation. According to the defendant, the applicable guideline for the offense charged in Racketeering Act 9 is Section 2G 1.3. The defendant ignores, however, that Section 2G 1.3 includes a cross-reference to Section 2G 2.1, where the offense level would be greater under Section 2G 1.2, and the offense involved causing, transporting, permitting, or offering, or seeking by notice or advertisement a minor to engage in sexually explicit conduct for the purpose of producing a visual depiction of such conduct. USSG Section 2G 1.3 C1. And all of this USSG, all of that are the groupings. Here, Jane testified that, well, the grouping procedures, that is the procedures of what should be grouped together. And then it tells you when you are to give like a point to the highest scores. I put like that, the highest scores, right? So when y'all saw me do that, when you saw me do 32, and then I gave a point to each one in J Bull's grouping that brought it up to 35, that's what I was doing. Let's see. Okay. Here, Jane testified that while she was in California, the defendant recorded sexual contact between Jane and the defendant. Reference. There is thus a preponderance of evidence that the offense involved causing a minor to engage in sexually explicit conduct for the purpose of producing a visual depiction of such conduct. Number 3, custody care or supervised enhancement, Section 2G2. 0.1b5. The defendant objects to the 2-level enhancement pursuant to USSG Section 2G2.1b5. Section 2G2.1b5 applies if the minor was otherwise in the custody, care, or supervisory control of the defendant. That the government submits that the evidence established that Jane's parents had entrusted Jane to the supervision of the defendant, purportedly to assist Jane with her musical career, after which Jane lived with the defendant. Government Exhibit 476A and 475A. Note authorizing Juice's mother to have custody over Jane until she turned 18 years old. Juice's mother? I thought that was some other lady from Sony. Okay. Jane testified that after learning she was 17, the defendant told Jane that she would need to be homeschooled and living with him in Chicago. So the defendant and Jane convinced her parents to allow her to be homeschooled and to be in Chicago so that I could learn more musically. And the defendant had her parents sign a document consenting for her to be in Chicago under a woman that he had known. Reference. Jane testified that she and her parents knew Juice's mother, the guardian chosen by the defendant, only through the defendant. Therefore, the enhancement for Jane being in the custody, care, or supervisory control of the defendant applies. Racketeering Act 10, sexual exploitation of a child, Jane Doe number 5. Jane, commission of a sexual act enhancement. The defendant raises several objections to the applicable guidelines calculation as to Racketeering Act 10. First, the defendant objects to the 2-level enhancement pursuant to USSG Section 2G2.1B2A, which applies where the offense involved A, the commission of a sexual act or sexual contact In the defendant's view, the offense is duplicative of the sexual conduct in the base offense level. As described above, he is wrong. Sexually explicit conduct does not require a sexual act or sexual contact. Sexually explicit conduct defined by 18 U.S.C. 22562 CUSSG Section 2G2.1, Application Note Number 1, includes, among other conduct, lascivious exhibition of the anus, genitals, or pubic area of any person. By contrast, a sexual act or sexual contact defined by 18 U.S.C. Sections 2246.2 and 2246.3. Damn. See USSG Section 2G2.1, Application Note Number 2, does not include and goes well beyond such conduct. Instead, covering contact beyond certain body parts and intentional touching of body parts. Accordingly, the enhancement is not duplicative. Number 2, use of an interactive computer service enhancement. Section 2G2.1b6. The defendant objects to the application of a two-level enhancement for the use of a computer or interactive computer service to induce the minor engage in sexually explicit conduct pursuant to USSG Section 2G2.1b6. Section 2G2.1b6 provides that the two-level enhancement is warranted where, if for the purpose of producing sexually explicit material, the offense involved the use of a computer or interactive computer service to, 1, persuade, induce, entice, coerce, or facilitate the travel of a minor to engage in sexually explicit conduct, or to otherwise solicit participation by a minor in such conduct, or 2, solicit participation with a minor in sexually explicit conduct. USSG Section 2G2.1b6. The government submits that the enhancement is properly applied. The defendant stayed in touch with Jane by cellular telephone and regularly used a cellular telephone to communicate with Jane in order to induce her to travel to see him and to instruct her to meet him in a location where he intended to record sexual activity. Government Exhibit 157 shows extensive communications via cellular telephone that the defendant had with Jane prior to turning 18 years old. Number 3, sadistic conduct enhancement, Section 2G2.1b4. The defendant objects to the application of a 4-level enhancement pursuant to USSG Section 2G2.1b4. Section 2G2.1b4 provides that the enhancement applies when the offense involves material that portrays a sadistic or masochistic conduct or other depictions of violence. USSG Section 2G2.1b4. The masochistic I'm gonna get that word right one day, conduct or other depictions of violence. The government agrees that there was no evidence. Oh, wait a minute. Okay. The government agrees that there was no evidence that the defendant produced visual depictions of Jane that included sadistic or masochistic conduct or other depictions of violence while she was under 18 years old, and therefore submits that this enhancement is not warranted. Okay, who they disagree with? Wait a minute. Okay, so they agree with the defense on that. The government further disagrees with the probation department's contention in the PSR addendum that according to the principles of relevant conduct, the defendant's use of sadistic punishment as to Jane warrants this enhancement. PSR addendum at 13. As described above, the government submits that the conduct that forms the basis for forced labor predicate Racketeering Act 11, which the government agrees does not involve sadistic conduct on the part of the defendant, should be treated as a separate offense from this predicate, and therefore the fourth level enhancement should not apply here. Okay. Okay. It's cold as hell in here. The custody, care, or supervising enhancement, Section 2G2.1B5. The defendant objects to the two-level enhancement pursuant to USSG Section 2G2.1B5. For the reasons described in more detail above, the enhancement for Jane being in the custody, care, or supervisory control of the defendant should apply. Reference. J. Racketeering Act 11, Forced Labor, Jane Doe number 5. As to Racketeering Act 11, the defendant argues that the government did not establish that the defendant used force or the threat of force to cause Jane to engage in sexual contact with others, but concedes that if there was such evidence, he agrees with the probation department calculation as to the applicable guideline for this act. However, as set forth above with respect to Racketeering Act 6, forced labor to Geronda, the government submits that because the conduct was not committed in the territorial jurisdiction of the United States, the defendant did not commit a violation of 18 U.S.C. Section 2241 or 2242, and therefore the defendant did not commit that offense as required for an enhancement under Section 2H4.1B4. Nonetheless, there is a preponderance of evidence showing that the defendant did use the threat of force to cause Jane to engage in sexual acts with others. As Jane testified at trial, which testimony was corroborated by, among other things, letters recovered from the defendant's residence and storage facility. That damn storage. The defendant regularly spanked or chastised and otherwise physically assaulted Jane when Jane broke any of the defendant's many rules. Immediately before Jane first had sexual contact with Alex, also known as nephew, the defendant spanked Jane and two of his other girlfriends approximately 15 times each, and then continued to hit Jane more. Reference. Therefore, Jane testified that she had sexual contact with others at the defendant's direction, not because she wanted to, but rather because she feared consequences that would follow any refusal. Reference. Testifying that she had sexual contact with nephew because I would have gotten chastised regardless, so it wouldn't have made a difference. According to the court, may depart upwardly as to this particular racketeering act because the adjusted offense level does not take into account the defendant's commission of criminal sexual abuse. So she wants the judge to sentence outside the guidelines with regards to this matter on an upward departure, meaning more time. Okay, Racketeering Acts 12 and 14, Mann Act violations, Jane Doe number 6, faith. As to Racketeering Acts 12 and 14, the defendant objects to the four-level enhancement pursuant to USSG Section 2G1.1B1. The four-level enhancement is warranted if A, subsection A, 2 applies, and B, the offense involved fraud, or coercion. USSG Section 2G1.1B1. At issue is only whether the offense involved fraud or coercion. Here, a preponderance of the evidence supports that the offense involved fraud, i.e., that the defendant knowingly made a misstatement or omission of material fact to entice the victim. A material fact is one that a reasonable person would expect to rely on when making a decision. Specifically, the defendant induced Faith to travel to New York and engage in sexual intercourse, but intentionally concealed from her that he had contracted genital herpes. As a result, the offense involved fraud, and the court should apply the enhancement. L. Racketeering Act 13, Forced Labor of Faith, Jane Doe number 6. As to Racketeering Act 13, the defendant claims that there was no evidence that Faith was forced or threatened with physical harm to give the defendant oral sex and therefore objects to the application of USSG Section 2H4.1B4. The government does not contend that the defendant used force or expressed threats of physical harm, but submits that Section 2H4.1B4 applies because his conduct still amounted to criminal sexual abuse. And remember, I told you, you can stick domestic violence and all type of stuff like that under sexual abuse, but you can't stick sexual abuse in domestic violence when you're doing your charging. As noted above, Section 2H4.1B4 applies when any other felony offense was committed during the commission of or in connection with the peonage or involuntary servitude offense. USSG Section 2H4.1B4. Application Note 2 provides that any other felony offense means any conduct that constitutes a felony offense under federal, state, or local law other than offense that is itself covered by this subpart. USSG Section 2H4.1. Application Note number 2. When Section 2H4.1B4 applies, the guidelines dictate that the offense level should be increased to the greater of 1, the adjusted offense level according to Section 2H4.1A to B3, plus 2 levels, or 2, the offense level form the offense guideline applicable to the other offense, plus 2 levels provided it is not greater than 43. USSG Section 2H4.1B4. The government respectfully submits that the defendant's conduct as to Faith included causing her to engage in a sexual act by placing her in fear, as found by the jury when it concluded that Racketeering Act 13 was proven and that conduct would amount to a violation of California Penal Law Section 518, which makes it a felony to obtain consideration, including sexual conduct induced by a wrongful use of fear, and is akin to a violation of 18 USC Section 2242. Specifically, as Faith testified at trial, after essentially isolating her for several hours in his Sprinter van and then inside a recording room at a studio in Los Angeles, the defendant led Faith into a room the size of a walk-in closet within the larger recording room. Reference. When Faith entered, she saw a gun on the ottoman in the room. The defendant's demeanor changed and he got real serious. Reference. He moved the gun near him, sat down in a chair, and told Faith to stand across from him. Reference. After taking photographs of Faith and getting irritated with her for not being sexy enough, the defendant asked Faith a series of intrusive questions, including asking her, how many men have seen her naked, and how many male friends she had, telling her there would be consequences if she did not answer truthfully. Reference. When Faith responded in a manner he did not like, the defendant stated, "Do you want to take that back?" Reference. Faith said no. The defendant then paused and got a stern look on his face, telling Faith that he and her father had the same gift of spiritual discernment and that he would know if she was lying to him. Reference. Faith was taken aback. Reference. The defendant then stood up and put a pillow on the floor and told Faith to get on her knees, which she did. Reference. With his gun nearby, the defendant then pulled out his penis, grabbed the back of Faith's neck, told her to suck his dick, and pushed her forward to give Kelly oral sex, but she did so. Wait a minute, hold on. Suck his dick and pushed her forward so her mouth made contact with his penis. Reference. Faith was intimidated and did not want to give Kelly oral sex, but she did so. Reference. Throughout, Kelly's hand remained on the back of her neck, guiding her. Reference. Faith did not feel like she could leave the room because she was under Kelly's rules and he had a weapon, so she wasn't even going to step out of line. Reference. In these circumstances, it is clear that the defendant placed Faith in fear to cause her to engage in oral sex with him. The enhancement is therefore warranted. Under that analysis, the adjusted offense level would be 32, i.e., the base offense level of 30 pursuant to USSG section 283.1b2 plus 2 levels pursuant to USSG section 2H4.1b4b. M. Aggravating role enhancement section 3b1.a. Finally, the government submits that notwithstanding the defendant's objection, May 27, 2022, sentencing memorandum 16, a 4-level role enhancement under USSG section 3b1.1a is warranted. Section 3b1.1a provides for a 4-level enhancement where a defendant was an organizer or leader of a criminal activity that involved 5 or more participants or was otherwise extensive. USSG section 3b1.1a. The application notes explain that while a participant is a person who is criminally responsible for the commission of the offense, in assessing whether an organization is otherwise extensive, all persons involved during the course of the entire offense are to be considered. Thus, a fraud that involved only 3 participants but used the unknowing services of many outsiders could be considered extensive. USSG section 3b1.b, application notes 1 and 3. Application notes 4 makes clear. In distinguishing a leadership and organizational role from one of the mere management of supervision, titles such as kingpin or boss are not controlling. Factors the courts should consider include the exercise of decision-making authority, the nature of participation in the commission of the offense, the recruitment of accomplices, and claimed rights to a larger share of the fruits of the crime, the degree of participation in planning or organizing the offense, the nature of the scope of the illegal activity, and the degree of control and authority exercised over others. There can, of course, be more than one person who qualifies as a leader or organizer of a criminal association or conspiracy. This adjustment does not apply to a defendant who merely suggests committing the offense. USSG Section 3B1.1, Application Note 4. Furthermore, in United States versus Ivenga, the Second Circuit explained that in a RICO offense, a defendant's role adjustment is to be made on the basis of the defendant's role in the overall RICO enterprise. 568 F.3D 8899, Second Circuit, 2009. Viewed through that lens, it is clear that the defendant was the leader of the enterprise and that the 4-level enhancement is warranted. In opposing the role enhancement, the defendant argument is twofold. First, he challenges the existence of the enterprise, but the jury clearly and necessarily rejected that contention when it found him guilty of racketeering. Second, he suggests that a role enhancement is only warranted if the activity overseen by the defendant involved 5 or more individuals also engaged in criminal activity. Even assuming arguendo, meaning for the sake of the argument, that there were not 5 participants involved in the criminal activity, as that term is defined, the government submits that the criminal activity overseen by the defendant was otherwise extensive. The defendant oversaw dozens of employees and associates, i.e., the inner circle, who knowingly or not were critical to his ability to carry out the offenses he committed. Case law. In determining the number of participants, a district court considers 1, the number of knowing participants in the criminal activity, 2, the number of unknowing participants whose activities were organized or led by the defendant with specific criminal intent, and 3, the intent to which the services of the unknowing participants were peculiar and necessary to the criminal scheme. Thus, the enhancements are warranted. Give me a minute, y'all. Let me take a drink. Let me check on you. Y'all good? Child. Oh, thank you, Red Bunny. I ain't see you. Thank you so much. So sweet. I appreciate you. Let me shout some more y'all out while y'all in here. Hey, I think I got Queen Diva. Hey, S Nice. Hey, Zoe. Queen. Samantha Nicole. Leslie Jennings, how you doing? Mod extraordinaire. Once again, thank you, Red. Hey, Jason Finch. Zoe. Hey, Elvira. Danny. Hey, Danny. Hey, Mama Danny. Hey, Mark Quinn. I think I got Karen J. Hey, MKVL Daddy. Love Sphere. Hey, Terry Williams. She said it sounds like a really bad porn movie. Child, they get graphic, right? They got me saying the D word and all kinds of stuff. Hey, liar. Got me in here saying all kind of stuff. Yeah, JoJo ass probably went to sleep, honey. Hey, cool BJ. Stilettos. I think I got Love's Fair. LaVale Marshall. The Cut Up King. Shawty. Okay. Woo. Yes, yes, yes. Shawty. Shout baby number one. Hey, Pumpkin. All right, let me get me one little snack. Give me 1 minute. I'm going to run to the kitchen. Oh, child. I'm back. That goddamn kitchen's a long damn way. Oh, thank you, Queen Chris. Oh, y'all so sweet to me. Oh, Lord, y'all so sweet to me. I appreciate it. I appreciate it. And shout out to Debo. Debo got in here last night and said, y'all appreciate Miss Walker. Y'all, let me see that super chat, whatever. I like Debo. He gets on my goddamn nerves, child. Child, he works my damn nerves. But I like, I like, I pretty much like everybody, you know. But I appreciate y'all. I surely do. So we got to get down to, because we got to get down to that goddamn those points. So I think I'm almost getting to it. Y'all just bear with me. Hang on in there. We done been up later than this. We gonna get to, because we have to knock this shit out. Okay? Okay. Hold on. All right. Now we are on Okay, now we on the points, baby. Now we on the points. We're on the points. Now, this is the government's points, okay? Government points. Now, remember, J-Bo grouped them up. So, when it comes to the Racketeering Act 1, bribery, the base offense level is 12. The adjusted is 12. So, and J-Bo says in hers, hold on. $12. Okay. The government says that Racketeering Act number 2, Stephanie, at base level is 2-point enhancement, brings up the adjusted offense level to 34, and J-Bo says it should be just 32. Let's see. Okay, J-Bo got 3 and 4 grouped together. The government has hold on, 10, 8, 7, 6, 5. I don't have number 3 and 4. Okay. Well, the government says the Racketeering Act number 5. All right. That's with Jane Doe number 4. Right. That's with Geronda. So they have the base is 24. Participant plus the participant otherwise unduly influence of a minor plus 2. Plus offense involved use of a computer or interactive computer services. That's another 2. And offense involves sexual act or sexual contact. That's another 2. So that's 26, 28, 30. So that's a 30 for Racketeering Act 5 for Geronda. J-Bo has it only at a 24. Then you have Racketeering Act 6. That's for Geronda as well. Is a base. The government has a base level of 22. The adjusted offense level of 22, and J-Bo has it as Racketeering Act 6. Now J-Bo has it as a 32. Let me make sure I'm looking at this right, because why would she have it so high? Hold on, let me go to her grid. Racketeering Act. Yep. Oh, but she grouped them together. Okay. Okay. Racketeering Act 6. She has it as a 32. All right. Now, you have government has Racketeering Act 7, sexual exploitation of a child, gender number 4. That's Geronda again. They have that as a 32, the base level offense. Then they added 2 more points for offense involves sexual act or sexual contact. Another 2 points for offense involved use of a computer or interactive computer services, which gave it an adjusted offense level of 36. And that is Racketeering Act 7. Why am I going now? So Racketeering Act 7 is 32. So is the government. Racketeering Act. So the government got that as a 36. Racketeering Act 8, Mann Act violation with regards to Jane Doe number 5. They got the base level offense at 14, plus offense involving fraud. They gave it a 4-point enhancement. Then the adjusted offense level, the government has it at 18. So that's Racketeering Act number 8. Jabo got that as a 14. Okay, the government has Racketeering Act 9, Mann Act violation, Jane Doe number 5. Okay, they got the base offense level of 24, plus 2 more points because she was a minor, was otherwise in custody, care, or supervisory control of the defendant. That's 2 points. Participant otherwise unduly influenced a minor. That was another 2 point. Offense involved the use of a computer or interactive computer service. That was another 2 point. Offense involved sexual act or sexual contact. Another 2 point, which made that 32. The adjusted offense level 32. 24, 26, 28, 30, 32, right? That's Racketeering Act 9. The government Jabo has that as a 24. So she said the government legis base. Right. The government has that as a 32. And Jabo has it as 24. See, they so far apart on a lot of these. Racketeering Act 10, sexual exploitation of a child, Jane Doe number 5. The base offense level for that one is a 32. Offense involves sexual act or sexual contact is 2. More points. Offense involving use of a computer or interactive computer services is another 2. And a minor was otherwise in the custody care of supervisory control of a defendant. It's another 2. So they came out to 36. 24, 34. Wait a minute. 34, 36, 30. That should have been 38. Racketeering Act 10. Okay. That's their math, not mine. Jabo has it as a 32. You see clearly that's 6 more points. So I don't know what's wrong with somebody's math. Hold on. Okay. Racketeering Act 11, the government has that as a 22. That's Jane Doe number 5. Racketeering Act 11 is a 22. Jabo has that as a 22. Racketeering Act 12, Mann Act violation, Jane Doe number 6. That is my favorite, Faith. Base offense level 14, plus offense involving fraud. That's 4 more points. Adjusted offense level of 18, right? Racketeering Act 12. Racketeering Act 12, Jabo has that as 14. Okay. Racketeering Act 13, forced labor, Jane Doe number 6. Okay. Base offense level is 30. Plus 2 level increase is 2 more points, which is adjusted offense level of 32. That's Racketeering Act number 13. What does J-Bo have? She has it as 22. That's like a whole 10-point difference. Wow. Racketeering Act 14, Mann Act violation, Jane Doe number 6, faith. Base offense level is 14. Plus offense involved fraud, that's another 4. Adjusted offense level of 18. Okay, so that one, Racketeering Act 14, Mann Act, 18 points, right? They have that at, J-Bo has it as a 14. Now, so now J-Bo and on hers, right? In this area right here that I'm concentrating on. J-Bo didn't, she only accessed 3 points, and that was to the higher group. There is an instruction under that USSG to do that. But the government, as you see, has come up with something different. Okay, they broke it out into the multiple racketeering act analysis. They gave Racketeering Act 1 no points, Racketeering Act 2 1 point, Racketeering Act 5 a half a point, Racketeering Act 6 no point, Racketeering Act 7 1 point, Racketeering Act 8 0 point, Racketeering Act 9 1 point, Racketeering Act 10 1 point, Racketeering Act 11 0 point, Racketeering Act 12 0 points, Racketeering Act 13 1 point, Racketeering Act 14 0 point, with the total units of 5.5 points. So plus levels add, and this is the USSG section 3D 1.4. That's where they get the plus 5 from. Plus the aggravated role plus 4, which gave him a total offense level per the government of 45. So it's higher than the 43. Yes, so don't pass out. Please don't pass out in the chat. Or whoever's listening and that's looking in the window. Please continue to look in the window, and while you're there, push the like button. Yes. So they got it to 45. That's why they're asking for 25, more than 25 years, but 25 being the minimum. It just says based on the total offense level of 45 and a criminal history category of 1, because he is a first timer. The applicable guideline range is life imprisonment. So it says a sentence in excess of 25 years is warranted. The government respectfully submits that a sentence in excess of 25 years is appropriate in light of all relevant factors, including the nature and circumstances of the offense, the history and characteristics of the defendant, and the need for the sentence to reflect the seriousness of the offense, to promote respect for the law, to provide just punishment, to afford adequate deterrence, and to protect the public. it says two. A, 2A, legal standard. The sentencing guidelines are advisory, not mandatory. Remember I told you that? So it's not, the guidelines aren't where the government has to go by a mandatory minimum and the maximum. No, they are only advisory. They could sentence, however. They just have to justify it. It says case law. However, the Supreme Court held in Booker that the sentencing court must consider the guidelines in formulating an appropriate sentence. In Gall versus United States, 55-2 U.S. 38, 2007, the Supreme Court set forth the procedure for sentencing courts to follow in light of Booker. A, district court should begin all sentencing proceedings by correctly calculating the applicable guideline range. As a matter of administration and to secure nationwide consistency, the guidelines should be the starting point and the initial benchmark. All right? So, you remember J-Bo made her benchmark at 14 years to 17 and a half. Okay? The government is asserting, and they have Booker to back them up, is that as a matter of administration and to secure nationwide consistency, the guidelines should be the starting point and the initial benchmark. Gall 552 U.S. at 49. Next, a district court should consider all of the section 3553A factors to determine whether they support the sentence requested by a party. In so doing, the district court may not presume the guidelines range is reasonable. The district court must make an individualized assessment based on the facts presented. B, analysis. Based on the factors set forth in 18 U.S.C. section 3553A, a sentence in the excess of 25 years is appropriate in this case. 1, nature and circumstances of the offenses. Relying on his inner circle and his fame and wealth as a successful R&B singer, the defendant engaged in a conscious, repeated pattern of enticement of minors, sexual exploitation, and sexual abuse, among other crimes, that spanned a period of decades. Through his actions, the defendant exhibited a callous disregard for the very real effects that his crimes had on his victims and has shown no remorse for any of his conduct. Indeed, the defendant's decades of crime appear to have been fueled by narcissism and the belief that his musical talent absolved him of any need to conform his conduct, no matter how predatory, harmful, humiliating, or abusive to others, to the structures of the law. The nature and circumstances of the defendant's crimes are exceptionally serious. Racketeering, I'm getting tongue-tied, honey. A crime that penalizes individuals like the defendant who commit a pattern of certain crimes backed by a network of others is a serious crime that warrants a significant punishment, as are the crime of bribery, enticement of minors, sexual exploitation, and sexual abuse. In many ways, however, the defendant's conduct was more nefarious than the typical cases involving such crimes because he committed these crimes using his fame and stardom as both a shield which prevented close scrutiny or condemnation of his actions and a sword which gave him access to wealth and a network of enablers to facilitate his crimes and an adoring fan base from which to cull his victims. Ooh. Put simply, the defendant's crimes were calculated, methodical, and part of a long-standing pattern of using his platform as a larger-than-life musical persona and his deep network to gain access to teenagers, many of whom were particularly vulnerable, and then to exploit them for his personal gain and sexual gratification. Aaliyah was only 12 at the time the defendant's sexual abuse of her began, and 15 when he secretly and fraudulently married her in an effort to protect himself from the consequences of that abuse. Stephanie, 17 years old when the defendant sexually exploited her, testified that she was previously sexually abused and that she was really scared when the defendant told her that he was going to make a sexually explicit video of her. Reference. That was definitely the hardest time of my life. I had a very low self-esteem. I had already been through sexual trauma and abuse within my family. My first boss by men on the street. It was the hardest time of my life. I was very vulnerable. Reference. The defendant's exploitation of Stephanie was exasperated when the defendant refused to return or destroy the video recordings he made of her, despite her pleas for him to do so. Reference. Sonia, then an aspiring radio disc jockey in her 20s, recounted in vivid detail how she awoke in the defendant's studio to find her underwear removed and the defendant fixing his pants, evidencing that he had sexually assaulted her while she slept. Deronda, 16 years old, when the defendant abused her, broke down in tears when she read from a journal entry about the last time the defendant abused her. She read, I went to Rob's house and Rob called me a silly bitch. Rob slapped me 3 times. He said if I lied to him again, it's not going to be an open hand next time. He spit in my face and in my mouth and slapped me in my face again for the 4th time. He choked me during an argument. I had sex with him. I had oral sex with him. And I became fed up with him and I went home and confessed to her mother. Jane, 17 years old, when the defendant started to abuse her, testified that her abuse, which caused her to forego attending her senior year of high school in person, left her with an incurable sexual transmitted disease and caused her to endure physical abuse almost every 2 or 3 days during the entire 4 years that she spent with him. Faith, 19 years old, when she first met the defendant, testified that she exposed her to genital herpes without her consent, being increasingly controlling, and forced her to give him oral sex after she broke one of his rules in Los Angeles. At his trial, many of the defendant's victims overcame immense fear and trepidation and relived some of the worst experiences of their lives in a public courtroom in front of the man who abused them and, in some cases, controlled every aspect of their lives, from when they could go to the bathroom to who they could look at and whether they could leave a room or a bus, for months or even years. The defendant likely believed that his very presence in the courtroom would intimidate and alter their testimony, but it did not. After years of the defendant having committed crimes with impunity, using his fame, money, power, and network to intimidate, silence, and threaten his victims, they were able to tell the jury and the court what they experienced in their veritable twilight zone that the defendant created and his inner circle sustained and helped protect. Many of those victims were subject to harassment and threats on social media, ooh, and otherwise. It was y'all niggas before, but before and after the trial from the defendant's supporters and loyal fan base, i.e., you niggas. The testimony of such victims is all the more remarkable given the methods of the defendant used to prevent his victims from coming forward in the first place. The defendant regularly required his victims to pen letters with embarrassing falsehoods, which letters he maintained in a storage facility under lock and key, ready for use if anyone dared to betray him by exposing his crimes. In fact, when Jane testified, the defendant cross examined her with the very letters containing embarrassing falsehoods that the defendant directed her to write and that he maintained in pristine condition using document protectors for his protection. For the defendant also entered into settlement agreements that prohibited the parties from ever speaking of the time they spent with the defendant and called for the entry of liquidated damages should they violate his provision. Indeed, his methods worked so well that some potential victim witnesses simply refused to meet with the government during the investigation, citing the extraordinarily harm that would result from reliving that period of their lives and fearing that meeting with the law enforcement would expose them to financial ruin. Those who did betray the defendant exposed themselves to full scale retaliatory tactics by the defendant and the network backing him. For example, after Faith filed a civil lawsuit against the defendant, along with his one time business manager, Donnell Russell, and Russell's mother, arranged for compromising photographs the defendant had taken of Faith to be sent to her civil attorney, her civil lawyer in Brooklyn, New York, with a letter threatening, among other things, to release uncropped versions of the photographs publicly if she did not abandon her lawsuit and stop speaking publicly about the defendant. Faith did not withdraw her lawsuit. Thereafter, Russell sent threatening texts to Faith and her mother, including the same crop photographs with the ominous words, "Pull the plug or you will be exposed," and criminal charges to follow, and further created a Facebook page using an alias, Kalon Don, called Surviving Lies, where he ultimately followed through on those threats and publicly posted graphic photographs of Faith before Facebook took the photographs down. The defendant also ensured the protection and continuation of his enterprise and his ability to engage in criminal conduct by demanding absolute loyalty and sometimes using threats against others, including those in his inner circle. For example, as he testified at trial when Demetrius Smith expressed doubt about his plan to marry the 15-year-old Aaliyah to avoid exposure of the defendant's sexual abuse of Leah, the defendant told him he needed to pick a side. Reference. On another occasion, when the defendant faced another legal predicament involving another young female, he told Cheryl Mack that she needed to pick a team and that in these types of situations, people come up missing, which Mack clearly understood as a threat. Reference. In the months before his arrest, the defendant took another woman, Jane Doe number 19, that she needed to decide which team she was on, Team Kales or the other one, and that she had a beautiful family and she did not want to be handled a comment that Jane Doe number 19 construed as a threat. The seriousness of the defendant's crimes and the harm he caused is also laid bare in the sheer number of his victims and the 3 decades over which these crimes spanned. The indictment alleged charges related to 6 victims, and 12 victims testified at trial regarding the abuse the defendant committed. Finally, the pattern of crimes committed by the defendant demonstrates an escalation in the brazenness, with which he engaged in illegal conduct, As made clear through Jane's extensive testimony at trial, the defendant used physical violence and psychological manipulation to ensure that Jane and her other purported girlfriends afforded the defendant the adoration he demanded, obeyed every rule he promulgated, and complied with all of his demands, including having sexual contact with numerous other male and female partners on the defendant's command. A letter recovered showed the defendant would not allow one woman, then 26 years old, to use a telephone her father had bought her, and required her to ask permission from him to see her mother. And another note that was recovered by law enforcement, Jane recounted the defendant's instructions: trust daddy and do whatever he says, whenever he says, with no rebuttal, respect, disrespect, or rebellion. Government Exhibit 325. A video recovered from the defendant's residence showed the defendant violently spanking one of his victims, imposing severe pain and leaving the victims in tears, and then requiring her to walk back and forth naked, making humiliating and disparaging remarks about herself over and over again. In doing so, the defendant severely physically and psychologically scarred all of his victims repeatedly and consistently. A sentence in excess of 25 years is necessary to reflect the profound seriousness of the crimes committed by the defendant. 2. The defendant's history and characteristics. The defendant's history and characteristics also support a sentence in excess of 25 years. The defendant crimes were not arbitrary, aberrational. I'm sorry, aberrational. Okay. They were his regular mode of operation, which he had no intention of ceasing. Over the course of years, numerous women and girls filed lawsuits against the defendant, alleging various forms of sexual exploitation by him. Even assuming the defendant did not understand the harm he was causing to these women and girls before they filed those lawsuits, he certainly knew at the time he agreed to pay them hundreds of thousands of dollars. But these financial consequences did nothing to even curb, let alone stop, his pattern of abuse. Nor did the defendant 2002 arrest and eventual state trial in 2008 stop the defendant from repeatedly committing crime. If anything, the defendant's acquittal after his state trial appears to have emboldened the defendant with the belief that he was untouchable. And over the next decade, the defendant's crime continued unabated. Number 3, reflecting the seriousness of the offense, promoting respect for the law, and providing just punishment. The sentence must reflect the seriousness of the offense, promote respect for the law, and provide just punishment. 18 U.S.C. Section 3553A2A. As noted above, the defendant's offenses, racketeering, involved deterrence, that's right, deterrence, I said it right the first time, sorry about that, to criminal conduct and protect the public from further crimes of the defendant. 18 U.S.C. Section 3553A, 2B, and C. Under Section 3553A, A, 2B, there are two major considerations: specific and general deterrence. Case law. Given the breadth of the defendant's conduct and its continuity over a period of decades. The government has little doubt that if afforded an opportunity to offend again, the defendant would do so. The instant offenses and the defendant's history demonstrates that he poses a serious danger to the public. His actions were brazen, manipulative, controlling, and coercive. He has shown no remorse or respect for the law. As set forth more than a decade ago, several women and girls retained legal representation to pursue charges against the defendant as a result of harm he had caused them. The harms raised in these matters included the defendant having sexual contact with minors who were too young to consent to such contact, exposing women and girls to genital herpes and physical assault. As a result of the defendant's wealth, he was able to resolve those matters without facing criminal charges and instead paid his victims to settle these cases. Notwithstanding this opportunity to reform his behavior a second, third, and fourth time, the defendant was not deterred and he continued to engage in criminal conduct. In fact, his conduct escalated. As noted above, the defendant also previously faced criminal prosecution in Cook County, Illinois, for sexual exploitation a minor by producing a videotape of her engaging in sexually explicit conduct. Putting aside his guilt as to those charges, there can be no doubt that the defendant was then on notice as to the criminality of such behavior, its seriousness, and penalties he faced for engaging in any such conduct. But again, that experience did not deter the defendant from engaging in criminal activity, including the very type of conduct with which he was then charged. As a result, the government respectfully submits the defendant is unlikely to be deterred from further sexually abusing and exploiting children and others, and the sentence should therefore incapitulate the defendant for a lengthy period of time to prevent him from further victimizing others. Incapacitate. Whew. The sentence sought by the government would incapacitate the defendant until he reaches his 70s. Oh, God damn. Let me see. Y'all do the math on that. So if he do 85% of 25, isn't that like 18 years? And what is he, 55 now? Okay. Given the need for specific deterrence and incapacitation, the government respectfully submits that a shorter sentence would be insufficient to adequately protect the public. A significant sentence is also necessary for general deterrence. While the government doubts that the defendant will be deterred, a lengthy sentence of imprisonment will serve to deter others, including those with wealth, fame, and outsized power, such as status brings from engaging in similar crimes. This is particularly so given the high-profile nature of the defendant and the likelihood that the length of his sentence would be widely publicized. Number 5, avoiding unwarranted sentence disparities. Finally, a sentence in excess of 25 years is necessary to avoid unwarranted sentence disparities among defendants with similar records who have been found guilty of similar conduct. A fine within the guidelines range is warranted. The government also seeks the court to impose a fine. Section 5E1.2a of the guidelines provides that the court shall impose a fine in all cases except where the defendant establishes that he is unable to pay and is not likely to become able to pay any fine. the defendant bears the burden of proving an inability to pay. Case law. In this case, the defendant cannot sustain this burden. The government respectfully submits that the sentence in this case should include a fine within the advisory guideline range of $50,000 to $250,000. Conclusion: in this case, all the facts and circumstances discussed above, a sentence in excess of 25 years is necessary to achieve the purposes set forth in 18 U.S.C. Section 3553. Let me go back and read the footnotes real quick. Per Ms. Margaret, I'm a legal assistant. You know she busted our ass. Okay. All right. Stephanie is identified as Jane Doe number 2 in the third superseding indictment and the PSR. Number 2, the sexual contact between Stephanie and the defendant did not violate Illinois law. 3, Stephanie turned 18 in mid-October 1999. She could not recall whether this trip occurred before or after her 18th birthday. Number 4, Alexis is identified as Jane Doe 13 in the PSR and the government's in limine motions. Number 5, Lewis is identified as John Doe number 1 in the PSR and the government's in limine motions. Number 6, Geronda is identified in the third superseding indictment and the PSR as Jane Doe number 4. Dominique is identified in the PSR and the government's in limine motions as Jane Doe number 17. Number 8, notably in 2017, the defendant revealed to Faith that there is some females that I'm raising. I have a group of women that I've raised. He said some women have been with me for 5 years and some women have been with me for a year. Some women have been with me for 15 years. Number 9, at trial, Dr. Don Hughes testified that isolation, indoctrination, intimidation, subjugation, surveillance, secrecy, humiliation, and collateral are all may be used as means of coercive control. Number 10, Jane is identified in the third superseding indictment and the PSR as Jane Doe number 5. Number 11, Kate is identified in the PSR and the government's in limine motion as Jane Doe number 11. Number 12, Jane Doe number 4 did not testify that the defendant video recorded the sexual acts that occurred on the first occasion that Jane Doe number 4 went alone to the defendant's residence. Number 13, Jane Doe number 4 did not testify that the defendant video recorded the sexual acts that occurred on the date in question when this conduct occurred in January 2010. Did not testify. Okay. Geronda testified that immediately before the defendant instructed her to give him oral sex, the defendant choked her, causing her to pass out, and thereafter caused Geronda to engage in sexual act by placing her in fear that she would be subjected to serious bodily injury, i.e., bodily injury that involves a substantial risk of unconsciousness. Number 15, even though the government submits that Section 2G 1.1 is the more applicable guideline, the government notes that the defendant was on notice of Jane's true age when the defendant first met Jane at the Dolphin Hotel in Florida in April 2015, and the police officers showed up at his hotel room and told him that her parents could not get in touch with her. (16) If the court does not find that the cross-reference to Section 2G2.1 applies, the government respectfully submits that a similar enhancement under Section 2G1.3b2b would apply. Number 17, the defendant also suggests that the enhancement was wrongfully applied because in Illinois, Jane could consent to sexual contact with the defendant at 17 years old. The government agrees that in Illinois, a 17-year-old boy could legally consent to sexual contact, but submits that the legality of sexual contact has no bearing on whether the enhancement amounts to double counting. Moreover, Jane testified that the defendant recorded her engaging in sexual contact in California, where there is no dispute that she was not legally able to consent to sexual contact with the defendant. Nor need the jury make a finding that the defendant suggests that the conduct occurred in California. So, hey, y'all, real quick, can somebody tell me the legal age of consent in California? I want to see if that's where they're going with this. I'm not on the screen, though, if y'all don't mind. Okay, 18, application note 2 provides for purposes of subsection B1, coercion includes any form of conduct that negates the voluntariness of the victim. This enhancement would apply, for example, in a case in which the ability of the victim to appraise or control conduct was substantially impaired by drugs or alcohol, right? This characteristic generally will not apply if the drug or alcohol was voluntarily taken. (19) The defendant was acquitted of charges in Cook County, but is now facing charges for that same conduct federally in Northern District of Illinois. The government does not seek for the court to rely upon that conduct in sentencing the defendant here. And I am done. I'm coming on around the front. I'm coming on around the front. Hey, okay. Let me go on and drop this thing and pin it. Actually, this is part of the sentencing materials, right? So they have, this was the last, I think J-Bo she got to put in her part 2, I think around June the 13th. So she may add maybe some response to this. She can, but her part 2, which is her expert mitigation, her mitigation report, that is what she was given time to. Let me go on mute real quick so I can pin this link. So, y'all, what in the world do y'all think? Now, I don't know where to go with this. Let me tell you why. What's up, Michelle? That's all. Who else up in here? Y'all, I sure do appreciate. It's 18 Queen Diva. Okay, thank you. Y'all so good. Hey, Star Child. They can speak, Karen. We also, a part of these sentencing materials, when they do the sentencing submissions, we should be able to see the letters from both sides, right? The letters supporting, R. Kelly, and the letters, the victims' impact statements and stuff. When I pulled up, what's that guy name? Who I did last night? Michael Williams. He had some letters in there. So hopefully we get to see him. Because, we ain't going to be minding our own business. Hey, Star Child. Woo, I got through that, honey. I didn't see much where I need to come back at a later date and come through it and break it down, because I kind of did a side-by-side of those groupings. Now, I told y'all, she pencil whipped them damn groupings. She pencil whipped them damn groupings, honey. And the government, I told the government can't represent, them points ain't right. But hey, that's J-Bo. You know how she do now. So, this is some good stuff. Now we getting down to it. Now, I don't know what to think. We saw where the judge was like, fuck that 5 years that they was, that the prosecutor hadn't agreed to. She gave his ass 9. The prosecutors in this case agreed to, well, I mean, it's not didn't agree to, but wants 25 or more. But do you think the judge would consider meeting somewhere in the middle, meeting like J-Bo's benchmark is as high as 17.5. Somewhere in the middle be like 20, 21 years. Do you think Judge Anna do that? Or do you think she's gonna agree with the prosecution and give him 25 plus? Like, what would be like, oh boy, because they got it coming out at a level 45, and it stops at technically stops at 43. 43 is life imprisonment. And you see, they use that. Remember, I was telling Levi, they use that word sadomasochist in his bond, and when those bond objections, because they want that translate in law as you are a danger. You see, they came right back there and used it, because now they're saying he don't need to ever be on the streets. If he don't need to be on the streets, that's more than 25 years. Oh, thank you, Michelle. Y'all don't have to do that. Y'all so goddamn. Y'all help me meet my quota this month, because you got to get over $100 before they cut your check. Oh, y'all so sweet. I'm about to cry. Y'all so good to me. I appreciate y'all. Yeah. So what y'all think though? Michelle, girl, I done knocked out, honey. Oh Lord, I done knocked out two side women. A motion of the acquittal, the new trial, and the response, and the breakdown, and one laugh. Honey, I was getting it. I don't know what the hell was wrong with me that day. Even Keller say you beast that. Yeah, even Keller gave me the goddamn. And you know when Keller gives you something, baby, you got the shit. Yeah. Thank you, Red Bunny. And I don't know why an idiot would think I wouldn't have a pacer. Well, I have a damn ID to go into ECF for when I do my school stuff and putting in dummy paperwork and stuff for my students to do their assignments off there and shit. But I would never use that to pull this paperwork up. I go through as a regular person and pay my bill on Pacer. Like what's fuck? And Quindiva, yeah, I'll shoot you. I'll download this and shoot this to you. But y'all, this is I don't know. I don't know how Judge Donnelly will break, because granted, 25 years, that's a lot of time. Do she have the heart to tack on more? Do she have the heart to tack on more time? That's a lot of time. And I think somebody had figured it out, and if he does the 85%, because you get like 54 good a good time and per year. And I think came out to 18. But so what that was, so he what 50? How old R. Kelly? Shit, I don't know. How old R. Kelly? Like 55? So they say he did 20 years. They'll make him 75 getting out. Do they want to keep him off the street? And see, the government wants to keep him off the street for the rest of his life. That's why they put that sadomasochism in there. That's a lot. That's a lot. They put some stuff in there. And see, I had J-Bo's up too, because she pencil whipped on that. I told you, on them goddamn categories. She did her own goddamn. J-Bo saying, and then if you go to her paperwork, let me put hers up here right quick so y'all can give y'all a refresher with how she did it, how she grouped it. Which in that area, in that USSG, you can group it. That you can group it, and you're supposed to, but the government of her came up to something different. See, she cited the same USSG section 3D1.2A, but she come out with something different. See right here, you see how she grouped them? And I read the guidelines in the government of what constitutes a group. And remember when I went to breaking down her group, remember I was asking, well, how she grouped this together? Because I had to pull up the indictment to see what the counts were. I'm like, well, how she grouped this together? So remember, she had the 32, and then you're supposed to give a point to the highest groups. So they gave a point right here, a point right there, and a point right there. That brought it to 35. And voila, that came up to 168 to 210, because he's in that level 1, that category 1. Totally different. Totally different. And then where is the tool? Oh, there go my tool. We can put these down. Let me see. What is one of those crimes he hit at? What 18, 24, 22? Let's see. That's a damn shame, honey. I know about damn hard, damn charges. Let me put up the PSR tool. Okay, so what is it? 18, what is it? 24, 22, is that it? Yeah, so that's one of them. So you see, so you know how, remember I showed y'all it starts off here like this. Then you see the fines. So remember in the back when I was talking, when the prosecutor was talking about the fines, so you could see what level where the fines, where the fines would work itself in. You're saying yourself, shit, you're in prison for life. How the hell you gonna pay a fine? So this is 18 USC 2422. It's one of the crimes he is accused of. And then you put in, let me see some of the stuff he got. He got aggravated role, put that in. We got minor. And it was organized, was the defendant organized leader of criminal activity that involved 5 or more participants, otherwise extensive. Okay. The defendant attempt to use person or less than 18 commits offense, avoiding detection or apprehension from the defendant. I ain't gonna use that. Defense clearly demonstrates itself. Okay, no. He's okay. They say so they did quote a 4B15. See, remember I was saying out of all those 4B15, this is the tool, right? This is the tool. So you see the section right there. I just clicked the 4B15. They mentioned that. What else? So, and that's how it's done, and that's the calculation of the month. Just in case it's whoever wasn't here to see me do that before. That's just shit like your pretty much your virtual PSR. So, but yeah. I don't know. I don't know what to say. I know majority of y'all not gonna agree with the 25 years. But it could be 25 to life. You're welcome, Shorty. Thank you. So you could see how, with that tool, how it may start out at a level, let's say it might start at a level 24. But when I get finished checking all those marks, and you see they reference that they considered him, what was that last one I had up? 4B point 1 point, 4B.1. So a repeat dangerous sex offender, so they're calling him dangerous. You see what I'm saying? When they use all those type of words or whatever, that is translation and legal talk. He don't need to be on the streets. Now, see, just say if he accepted his just say if he accepted responsibility. Let me show you how it goes down if he accepts responsibility, right? But you have to be careful of that, because accepting responsibility, guess what that's going to do? That's going to interfere with your appeal. So you can't do that. Right. So just say right here, we got 27 to 33 months. And if I click in here, does he accept responsibility for his offense? It goes down to 21 to 27 months. So that's how you get the points taken off. But you can't say all kinds of shit, because that is going to interfere with your appeal. So I don't know. Okay. Do he get checks just because the government is saying he needs them? That's what it sounds like you're saying. Say that again, liar. Do he get checks? Like, what you mean? Like money checks or checkups? That's why, I mean, I can't believe that we was up here last night just trying to get a sense of how Ann Donnelly sentenced and what her mindset is, and the damn prosecutor come on through with the damn paperwork today, because we was waiting on the paper. I said we were supposed to get paperwork on the 8th, and they came on through. Thank you, T Beautiful 68. Y'all so wonderful. Yes, because Prince and Michael Jackson didn't have social media with all that big mouth. Yeah. Did y'all hear how they said his fans on social media? Wonder who he talking about. Wonder who the prosecutors are referencing. Mm-hmm. Mm-hmm. Yeah, so this would be interesting for us to find out. It really would. And we got a pretty good synopsis from what was said in court and what the prosecutor tried to prosecutors tried to sell in court, right? Without going through the transcripts and stuff, we got a real good breakdown, good intel and stuff to what they were, what they was trying to get the jury to buy. And in several areas they reference, they did both. They reference where the people said that they were videotaped, and they also referenced where they said they had some type of tapes that showed this or that or whatever. Crazy. His ghost friends, but yeah. And you see in the what did I read? Something I read today. uh, from I think it was earlier, where no last night, where Judge Donnelly, they recognized that that guy Michael Williams had family that was standing by him and all of that. So that all that looks good, honey. All that looks good. Oh, you speaking about the points? Oh, do he get checks just because of that? Like, let me put that question together. Wait a minute. Um, still don't get it, liar. I'm thinking, and I could be wrong. I think she may give him a flat 25. Oh, is everything government wrote factual, or could they put BS in just to get what they want? Oh, okay. So now that he's been sentenced, right? The government gets to use that, as well as they get to. I'm trying to see how much if they, because during the sentencing materials, you get to kind of freestyle with the hearsay. You can freestyle with your theory, with your perspective, right? So, and as you see, a lot of what they were saying was what they perceived R. Kelly to be, manipulative and all of that. So this is still another persuading brief, right? A written argument, something, try to persuade the judge to accept what they say their accounts of the facts versus J-Bo's. I want to know. Now, I don't agree with J-Bo's groupings of those counts and stuff. And you see, okay, you can tell from the writing, you see J-Bo says it's one way, the probation report says it's another way, the PSR, and the prosecutor says it's another way. What the hell, what the judge gonna do? You know what I'm saying? Who is more accurate? Because they citing the same USSG. That's the area that deals with that, the points and all of that. Who got it right? This is a mess, y'all. I'm telling you, I wouldn't wish this on my worst enemy because this is a damn mess. And I wouldn't dare. Now, maybe if I'm bored, I have nothing to do tomorrow, maybe I'll try to go through and see who did the point assessment correctly. Because in some areas, you see where J-Bo and the government like 10 points apart. Mm. So what I will do, hmm, I'm trying to see. I don't, I don't remember that stuff like that no more. I don't. It's been a long time because I was always, just cutting the pleas and shit. We had to do this even when somebody take a plea. You still got to do all this, a good, good bit of it with sentencing. You still get a formalized sentencing, even though you took a plea, right? Because the judge has the option not to even take your plea, accept the plea. So you got to go through all of this anyway. I just want to know how could, yeah, if they using the same guidelines, how could the government and J-Bo be in some cases 10 points apart? How's that? You know what I want to do? Because I know Levi, for some reason, when how Levi is, he wants you to concede and see it his way. And I ain't gonna see it his way if it ain't there. But he kept using the term like the government would suppress the evidence if they discovered that some nefarious situation was going on between the lawyers and the the people on social media who he deemed the terrorists. I was trying to get him to realize that at most it might just create an indictment for whoever whoever committed the crimes. It's highly unlikely that they're going to throw a whole case out based on some charges that came about after the original charge. They don't have nothing to do with the charges. You know what I'm saying? Because you throw cases out if the whatever, some the new charges, what have you, directly impacts the current charges. If it's something nefarious that happened with regards to that charge, like somebody was framed or all of that, yeah. But not that if you discover a relationship with some and then so it could go technical like this. It could be legally technical like this. Like, all right, just say for instance, the attorney somehow form an attorney-client relationship with the terrorists, the aka the terrorists that Levi considers the terrorists. So they'll go through some type of probe to see what does a client attorney relationship exist. Then it might be a conflict of interest type situation, which I'm just hypothetical. So it's a different channels that it will follow before it'll be like, woo, just throw it all out. It don't work that way. This simply don't work that way. But I have no clue, honey. So anyway, y'all, I sure do appreciate y'all running up in here and hanging out with me and support me while I read all that nonsense. Remember, this is our channel. Thank you for your support in all these ways. And make sure you do all of that so we can do this. And we keep it, especially when I drop that. And the same thing goes for Club Blue. Thank you for your support in these ways. Make sure you do all of this so we can do this. And you know Club Blue keep it lit in the what? Chat and on the panel. Especially when we do that. And they are always, again, don't forget to do those things. And with that being said, what a day, what a night. Yes, oh, no problem. Thank y'all. I appreciate y'all. Thank y'all. Thanks to the host, the hostess, and the guests, and everybody else. Make sure you love someone, love yourself, and do something good for somebody else. To the next live, I appreciate y'all. Love you. Good night or good morning.